Good morning, all. This application hearing is in the matter of CFI 016-2025 before His Excellency Deputy Chief Justice Ali Madhani. The applicant is represented by Clyde & Co. Lead counsel is Mr. Patrick Thomason. The respondent is represented by Ibrahim Albana Advocates and Legal Consultants. Lead counsel is Mr. Sahel Rana. Thank you, Excellency.
Yes, Mr. Thomason, this is your application.
Yes, Your Honour, I appear on behalf
To
of...
strike out a particular of a claim in the case of entirety.
Yes, Your Honour, exactly. So the way that I propose to deal with my submissions this morning is first I'll make some introductory remarks. Second, I was going to deal with the background to the defendant's application. Third, I was going to deal with the immediate judgment application. And fourth, I was going to deal with the strikeout application. So that's how I propose to deal with it, unless, of course, you have any other ideas or would like to me to deal with any other points.
And no, I would like to ask you why the immediate judgment comes before the strikeout.
I was dealing with the immediate judgment application because it's one distinct claim, the principles are different, and to me it made sense just to deal with that one smaller matter before I deal with the bigger matter of strikeout.
Yeah, is that yeah, we do have is that the holiday claims, isn't it?
That's exactly one part of the defendant's application is immediate judgment in respect of holiday pay claims, so for accrued but untaken leave. Right. And on that point, the defendant's case is that the claimant had no annual leave at termination because the defendant had required him to take his annual leave and it was entitled to do so under the claimant's contract of employment.
Yeah, throughout the garden leave, I understand.
Yes. And then the strikeout application, the basic point at the core of the application is that the particulars of claim are defective. It's a manifestly bad pleading, which we say doesn't disclose any viable claims or causes of action. Your Honour, you will have read the particulars of claim and formed your own view, but in our submission, it's not an acceptable pleading and falls woefully short of what is required to properly particularize a claim. I'll develop this point, but the DIFC court is a commercial court. It's adversarial and there are strict rules of pleading, and that's for good reason. And it's so the parties know what claims they are to meet. And of course, the court must know what matters it's required to determine. And the corners of the dispute are set by the particulars of claim and the defence. And it's the defendant's position that the particulars of claim, other than in respect of the holiday leave claim, fails to properly plead any viable causes of action. And for that reason, the various claims in the particulars stand to be struck out. If you decide to strike out the particulars, the defendant's position is you should then dismiss the claims in their entirety. The claimant's position appears to be that he should be allowed to replead his particulars of claim or parts of the particulars. Now, I'll respond to this point in detail during the course of submissions, but the overall point is that you and the court needs to be satisfied that a repleading of the particulars of claim would lead to a viable claim. And as matters stand, the claimant has given no indication that an opportunity to replead would lead to a particulars of claim containing a claim with reasonable prospects. The claimant has not made any application to amend, and there's no draft particulars of claim before the court. So just to summarize the claims which you'll be considering in this application, there appears to be agreement on the heads of claim being pursued by the claimant. So in the application, the defendant characterized the claims as 5 different claims: a termination claim, vacation leave claim, victimization, 4th, discrimination, and 5th, express and implied terms. And the claimant has confirmed in his skeleton argument that the defendant has got that right. So paragraph 2 of the claimant's skeleton argument contain broadly the same heads of claim. The only difference from that list I've given you is that victimization and discrimination are merged into one in the claimant's skeleton, and also the express and implied terms claim has been reduced just to a breach of the implied term of mutual trust and confidence. So we say the court should focus on, of course, these 5 heads of claim. The particulars of claim contains a great number of paragraphs which have no bearing on any of the pleaded claims. So just by way of one small example, page 17 of the hearing bundle, page 17 takes you to partway through the particulars of claim. And just at the bottom of page 17, we have paragraph 18, and it describes a toxic environment created by the CEO, encompassing structural and systemic issues that have contributed to widespread dissatisfaction, refers to witness accounts corroborating, testimonies being critical to establishing a role in fostering a hostile workplace. These are not operative parts of the particulars of claim because they don't relate to any specific allegations or claims brought by the claimant. It's broad allegations relating to a widespread culture, which isn't part of the claim brought by the claimant. For reasons of proportionality, the defendant has not applied to strike this paragraph out, and it's not gone through line by line to strike out every irrelevant sentence, because that would not have been a proportionate use of the defendant's or the court's resources to go line by line through the particulars of claim. Instead, we're focused on the actual claims which have been brought, and that's what I'll do in submissions too. Before I deal with the background to this application, I just want to emphasize what this application is not. And this is just in response to some points made by the claimant in reply to the application. This application for strikeout and immediate judgment is not asking the court to make a determination on any disputed facts. It's pursued on the basis that particulars are defectively pleaded and the claims don't work in law. Even in respect of the immediate judgment application, there does not appear to be a dispute of fact. So when in the claimant's skeleton argument at paragraph 3, it said that the central dispute is the claimant's performance, that is completely wrong. The defendant is not asking you to make any determination at this hearing as to the claimant's performance. It's about the particulars of claim being bad and the claim's not having reasonable prospects. So when the claimant makes criticism of Mr. Rogers' witness statement in support of this application as being hearsay, that misses the point. He's not purporting to give any evidence about the underlying disputed factual matters. His statement setting out the undisputed factual matters in a balanced way and explaining the basis of the defendant's application so that the claimant's able to understand it. And in fact, in my submission, the defendant actually went above and beyond in that witness statement to explain very carefully the basis of this application. But it appears that the claimant or his solicitors remain under a misunderstanding as to what's being argued. Turning to the background to the application, I'll deal with it briefly, but I think it's important to explain why it is that we're here before you. It's relevant to the application itself, but it's also relevant to the matter of costs. And I'm not going to make submissions on costs now because, as I understand it, unless you indicate otherwise, once you've issued a judgment on this application, you'd invite submissions on costs, at which point the defendant would make detailed submissions on that.
Yeah, that's what you usually do, yes.
Suffice it to say for now, the defendant's been forced to make this application because the claimant's particulars are defective. The claimant has not sought to remedy those defects, and that's despite the defendant having given him the opportunity to do so. Indeed, the claimant had failed completely to engage in the defendant's criticism of his particulars of claim at all until the 29th of July, 2025, just 2 weeks ago. That's the first engagement we had. So just to set the background, the particulars of claim start at page 12 of the bundle. Can I check, have you had an opportunity to read through the particulars?
Yes, I did.
Okay, I won't spend long, but page 13 is the table of contents. And under the heading the claims sought, that should really be the operative part of the particulars of claim, where the detailed claims are set out, what the claims being brought are. But I think it's important to note paragraph 3, it summarised what the claims are. The claims before the DIFC courts, unlawful termination, unjustified and false mean of cessation of employment, etc. The claims seeks redress for procedural breach and damages under the DIFC employment law. So all of these claims are brought under the 2019 DIFC employment law. That's the entire basis of this claim. So at page 21 of the hearing bundle, we have the heading the claim sought, and there we have the termination heading. Throughout this whole section on termination, right through to paragraph 47, it's not pleaded anywhere which provision of the DIFC employment law was breached. I'll come back to this in more detail later, but it's not there. There's also not a separate section for discrimination or victimization. Paragraph 48 goes straight into a section on unpaid accrued leave and compensation breach.
I see that, yes.
Now, this section on unpaid accrued leave, this is a section where specific provisions and a specific breach is pleaded. And that's why we haven't applied to strike out this claim. We've gone for immediate judgment, not strike out, because actually specific provisions have been pleaded. And then at page 32 of the hearing bundle, paragraph 74, there's the heading remedy sought, and this is where all the claims trace through into remedy. And all of the remedies set out in this section are reliant upon the 5 claims which I set out earlier: termination, accrued leave, etc. Now, in the defendant's defense, which is at page 93 of the hearing bundle.
Listen, Mr. Thompson, you said the particular claim and the claimant submission were made on a narrative basis, and it's only you who have tried to build up kind of anticipated clusters of the claimant claims, like to draw a focus.
Yes.
And on what he exactly, how he exactly thinking and what he's claiming and what he's not happy with during his employment. Is that what you're saying?
Yeah, we found it quite hard to understand exactly what he was saying. We've tried to work out and characterize what those claims are, but have you got the claimant's skeleton argument in front of you?
Yes.
Because the claimant's skeleton argument on page 3, paragraph 2,
bear with me. What paragraph you're referring to, Mr. Thompson?
paragraph 2.
Yes.
It starts claims impugned.
Yes.
And then particulars of claim pleads 4 heads of relief: wrongful termination, unpaid annual leave, victimization and discrimination, and then breach of the implied duty of trust and confidence. So what I've taken from this is that the way the defendants characterized the 5 different claims is actually correct, because they're the same ones identified here. Subparagraph C, he's put victimization and discrimination within the same claim, but I think that doesn't make a difference. And then we've said there was an express and implied terms claim, and at subparagraph D, that's now the express term claim appears to have been dropped, and the implied terms claim seems to be narrowed to the implied term of mutual trust and confidence. So I think there is agreement as to the heads of claim before you.
Or at least no big difference between what you're both saying. Yes.
Yes, yes. So turning to the defense, which is at page 93 of the hearing bundle. I'm not going to spend long on the defense, but the first page is at page 93. And the point that I want to make is that throughout the defense, where the defendant believed that the claim, the particular claim was deficient and they stood to be struck out, it was said so. So page 101 of the bundle. Page 101, we have subparagraph B. That's the start of the page. And it's stated the pleading on breach of Article 60 is embarrassing for lack of specificity, and the necessary elements for claiming victimization are not pleaded. No protected act. 3, the other detriments are vague and unspecified. The claim is time barred. And then C, the victimization claim pleaded at paragraph 15 stands to be struck out under RDC 416A. So the defendant explained exactly the basis on which the claim was deficiently pleaded and explained that it stood to be struck out. And there's a number of other paragraphs throughout the defense where this is done. Unless it would assist you, I'm not going to go through every instance and every paragraph where this was said, but suffice it to say the defendant explicitly and clearly informed the claimant of the deficiencies in his pleaded case.
Mr. Thomason, if you allow me, I would like to reactivate the busy sign on my door, because every time someone comes and knocks, because I think it's, I do have a hearing sign that it shows red and like the judge in session. But apparently it's a green now, so it's inviting everyone to come and knock my door. I would activate that in a minute. I'll be back to you. You can go anywhere. I'm here.
Okay, thank you.
Yes, I'm back, Mr. Thomason. You may go on.
Thank you. So the next event I just want to take you to briefly is at page 195 of the hearing bundle. Page 195 is a letter from the defendant's solicitors on the 28th of April, 2025. And this is a letter in which the defendant's solicitors explained the basis of the strikeout and immediate judgment application which it intended to make. In relation to each of the causes of action, the defendant carefully explained how the particulars were defective. And then Over the page at page 196, under next steps, it was explained that our client intends to file an application seeking strikeout and or immediate judgment in respect of the entirety of your claimant's claims. The costs were explained, and then over the page was explained the purpose of writing the letter is to explain our client's position so your client has the opportunity to discontinue his claim before the costs were incurred. And then we asked for a response, either one, confirming the proceedings were discontinued, or two, if the claimant did not intend to discontinue, explaining why the defendant should not issue an application to strike out. The claimant has never replied to that letter. The claimant did not file a reply to the defense either. You will be aware, of course, that the claimant then filed an out-of-time application for an extension of time to file the reply. The application was made without any notice to the defendant and was a hopeless application, which you rightly dismissed. And then we come to the defendant's strikeout application filed on the 16th of May 2025. Because it was an ordinary application, the timescale for the claimant to file evidence in response was 14 days. The claimant did not file any evidence in response until the 29th of July 2025, when it filed various documents, including a reply to the defendant's strikeout. Now, I don't want to spend any real time on this, but in my submission, the claimant had completely flouted the timetable for filing evidence in response to this application. His position on the applicable rules of the RDC do not make any sense, but the defendant didn't want to waste any time on procedural matters, so it consented to the evidence being admitted almost 2 months out of time. The final procedural matter to mention is the claimant's request to produce, which was filed on the 10th of July 2025. So this request to produce was filed without having engaged with the defendant about it. It wasn't, there's no correspondence about it. And it's a request to produce asking for various documents from the defendant. It's quite extensive, but of course, the CMC has taken
That's over 70 days almost, yeah?
Sorry, can you explain? Could you ask again? Sorry.
So the claimants just come back after 70 days from the 28th of April letter, isn't it?
Are you referring to the 28th of April 2025 letter we were looking at?
Yes, yes.
Well, the claimant's never replied to that letter. We've not received a reply, but the claimant filed a separate request to produce. So this is the documents which follow page, well, it's page 633 of the bundle. So at page 633 of the bundle,
yes,
there's a schedule of documents that they're requesting. But we haven't had standard production yet. No time for filing request to produce has been ordered. The CMC hasn't taken place. You may have noticed in the claimant's skeleton argument, the claimant is asking for an order that the defendant give disclosure to the claimant of certain documents by the 29th of August. The court obviously can't deal with this matter today. The claimant hasn't made any application, and it's quite extraordinary that the claimant would try and ask for an order at this hearing. And these procedural methods I've explained to you, I say it's important context when the court is considering the strikeout application. And it's important context because the court will be required to consider the appropriate relief once the particulars are struck out. And the claimant's conduct in this litigation to date should give the court doubts about whether the claimant can be trusted to particularize a coherent claim. So dealing first with the vacation leave claim, the immediate judgment application, I'll deal first with the principles applicable to immediate judgment. It's sought under Rule 24.1 of the RDC, and that's the test is that the claimant has no real prospect of succeeding on the claim or issue, and there's no other compelling reason why the case or issue should be disposed of at trial. I've set out the applicable principles in my skeleton argument, paragraph 38 to 40. I'm not planning to take you to the relevant authorities, Your Honour, because you're no doubt very familiar with the authorities on immediate judgment applications, and I actually don't think that they're in dispute between the parties. Essentially, it's that the claimant must have a realistic as opposed to fanciful prospect of success, and we say this is a case where the court should grasp the nettle, give immediate judgment, because it's a short point of construction of a contract coupled with DIFC employment law, and the court has all the evidence necessary to make a determination. So turning to what the claim is, it's at page 26 of the hearing bundle. Page 26 of the hearing bundle, we've already looked at this, but this is the heading for unpaid accrued leave and compensation breach. And it's a simple claim. The claimant says he had 14 days of annual leave left and he should have been paid 71,000 dirhams. And he says the defendant failed to pay him that. And we can see how that's pleaded. So we have paragraph 51. Paragraph 51 of the particulars. Article 19(1)(c) of the DIFC employment law mandates all outstanding amounts related to accrued vacation leave be paid within 14 days. And under Article 19(2), a failure to make this payment results in penalties. And
so we have the annual leave entitlement followed by the statutory penalty together, yeah?
Exactly. Yes. Exactly. That's what he's saying. Annual leave wasn't paid within 14 days, therefore a penalty. And what the defendant says about this is, so in relation to Article 19(1)(c) and Article 28 of the DIFC employment law, defendant doesn't dispute that, of course, an employee is entitled to be paid for any accrued annual leave that remains at the end of the contract. The defendant doesn't dispute that Article 19 says if it's not paid, you have to pay a penalty. That's trite law. But the defendant's position is that no days of annual leave were outstanding on termination, so nothing was owed. And the defence is contained at page 117 of the hearing bundle. Page 117 of the hearing bundle, paragraph 53, subparagraph B, I'm just going to take you to. And yes, when the claimant's employment was terminated, he had 14 days of accrued but untaken leave. Refers to a settlement offer that was made, which the claimant didn't accept. And then by letter dated the 11th of December 2024, the defendant required the claimant to utilise all of his accrued untaken leave during his notice period, which he was entitled to do under clause 21.2d of the employment contract. And therefore, by the end of his employment, he had no remaining accrued annual leave. That's the defence in a nutshell. And to satisfy you that the claimant has no real prospect of this claim, I'll just take you through the building blocks of that defence to establish the defendant's case. So the starting point, of course, is the claimant's contract of employment, and that's at page 50 of the hearing bundle. So page 50, this is the claimant's employment contract. This is the copy that was exhibited to the claimant's particulars of claim. And the relevant provision for my purposes now is clause 21, which is at page 55 of the hearing bundle.
Yes,
Clause 21 is headed garden leave. And 21.1 says, following service of notice to terminate the employment by either party, the branch may by written notice place the employee on garden leave. So defendant's entitled to place him on garden leave. Contractual provision that doesn't take any interpretation really. And as a matter of undisputed fact, the claimant was placed on garden leave by the defendant. Claimant doesn't dispute that. And then clause 21 continues at 21.2, during any period of garden leave, subparagraph D, the bank may, at its absolute discretion, require the employee to take any accrued untaken annual leave. So again, it's not a clause requiring any interpretation. The defendant had a discretion to require the claimant to take his annual leave during his garden leave. And because the claimant was on garden leave, he had 3 months where he was still being paid a full-time salary, but not being required to work. And the defendant had a discretion to require him to use his annual leave during that period. The claimant doesn't dispute that his contract contains that clause. And the defendant's position is that it exercised the discretion contained in this clause and asked him to take his annual leave during his garden leave. And we can see that at page 90 of the bundle.
Page number again with the reference?
90.
90.
Page 90. It's still within the exhibits to the claimant's particulars of claim.
I see that. Yeah.
And it's dated the 11th of December 2024. From Natixis to the claimant, headed leaving arrangements. We can see at paragraph 1, it's explained, for the remainder of your 3-month notice period up to the termination of your employment on the 24th of January, you'll continue to receive monthly salary allowances and benefits as normal. So he was continuing to receive his pay as normal. He was just on garden leave. And then at paragraph 3, you are required by the bank to utilize all your accrued untaken holiday in the period prior to termination date in accordance with Article 29.2 of the DIFC law as amended and clause 21.1 of your employment contract. This means you will not be entitled to receive any additional holiday pay on termination. So the defendant exercised its discretion in accordance with the contract. The claimant doesn't...
Yes. Mr. Thomason, from my recollection, I think there is a disagreement between when this letter found its way to the claimant himself, and what I would like to tell me, at the highest of the claimant case, when, let's say, a termination is delivered to him or transpired to him, so what is the maximum length? What is the last day of his, let's say, notice period, according to the claimant's statement, if there is any?
Okay, so the first point is, I don't think there is a disagreement in relation to this letter as to when this letter made its way to the claimant. There's a dispute around when the termination letter found its way to the claimant. That's a different letter.
I see.
That dispute is a month earlier, roughly. So that dispute is the defendant says, we gave you the termination letter in person in late October. The claimant says, no, we only got it for the first time on the 11th of November. This letter is a later one, 11th of December 2024.
Oh, I see.
And no dispute has been raised about when this letter was received. And just for completeness on this point, I don't think the claimant could raise any dispute because at page 85 of the bundle,
yes,
this is a letter from Clyde & Co, defendant solicitors, to Ibrahim Al-Bana advocates and legal consultants, so the claimant's representatives, on the 12th of December. The letter we've just looked at was attached to this letter. So this was sent by the defendant's solicitors on the 12th of December to the claimant's solicitors. There can be no dispute that he received the letter of the 11th of December.
Yeah, well, there is still time in the notice period, isn't it? Yeah.
Yeah, well, he says he had 14 days left. The notice period ended on the exact date is the 24th of January 2025. So there's
so at least, yeah, 45 days from this letter.
Yeah, exactly. You asked another question. At the highest of the claimant's case, when the termination was delivered, what's the maximum length of his notice period according to the claimant's statement? I don't know the answer to that. I don't know what the claimant's case is. It's not stated anywhere. I will come to the termination and notice period and the terms of Article 62 later. I'll go through what the minimum notice period is according to the statute. I don't know what the claimant's saying on this point. And if the claimant addresses this in his submissions, I'll have to address it in reply, I think.
We'll hear from him, yes, later.
Yes. So this letter, going back to page 90 of the bundle, it was received by the claimant on the 12th of December, sufficient time to take the leave. There was a contractual power to do so. We say the claimant has no answer to this defence. So just to address the way that the claimant has dealt with this, page 625 of the bundle. Page 625, this is the material that the claimant has provided in reply to the strikeout. And paragraph 19 of 625, it said Article 27.3 requires agreement on leave dates. So the unilateral directive on the 11th of December violates statute and contract. And then it says the garden leave clause at 21.2d is discretionary and cannot retrospectively extinguish accrued entitlement. I mean, it's worth mentioning that the claimant isn't disputing receiving that 11th of December letter. He's just saying that Article 27.3 requires agreement. So I'll just deal with both of these points. The first point is the claimant has misunderstood what Article 27.3 of the DIFC employment law requires. Article 27.3 can be found at page 368 of the bundle.
Right.
So page 368, Article 27, subparagraph 3, an employee is entitled to carry forward accrued but untaken vacation leave into the next vacation leave year for a maximum of period of 12 months, after which any unused vacation leave shall expire. The amount of accrued leave to be carried forward may be agreed between the employer and employee, provided that nothing shall preclude an employee from rolling over at least 5 working days. It's about carrying forward leave into the next leave year. It says the amount that can be taken over depends on agreement, but it can't be less than 5 days. It doesn't concern arrangements for requiring an employee to take their unused annual leave during garden leave. This provision has no relevance to a situation where an employer asks an employee to take their unused annual leave during their
so you're saying
leave.
This is a situation where there is no next year?
Yeah. I mean, all this clause does is says, well, if you've got some leave left over, you are allowed to take that into the next year, at least 5 days, but your employer might let you take more. But it doesn't say your employer can't make you take that leave during your garden leave. It's just about what you can take into next year, but it doesn't apply because there was, exactly like you say, there was no next year. The claimant's employment was terminated and he was made to take his annual leave.
So in summary, you're saying carry forward would not apply to termination arrangement?
Yes. And because the defendant had made him take his annual leave, there was no annual leave to carry forward. there was nothing there. It was all used up. I mean, it's also worth mentioning that Article 27.3 is not pleaded as a breach in the particulars of claim either. So this would require an amendment if you wanted to include it. And I would say it doesn't have any prospects of success. So it's not a case where it'd be appropriate to allow him to amend to include reliance on this article. The second argument raised by the claimant in this reply that we just looked at is that clause 21.2d is discretionary. I'm not quite sure what the claimant is getting at there, because it's obviously a discretionary clause. It gives the defendant a discretion to require the claimant to take his leave. The plain meaning of clause 21.2d is a defendant can make the claimant do that, and it's not a matter of retrospectively extinguishing the claimant's annual leave entitlement. It wasn't extinguished. He was just required to use his annual leave. And so for those reasons, the claimant's claim for accrued but untaken leave has no reasonable prospect of success, or no real prospect of success, and there's no other compelling reason for it to be heard at trial. So you should give immediate judgment in respect of that claim. I'll deal next with the strikeout application. I first want to deal with some of the applicable law, and it's necessary to go into some of the authorities on this point. The starting point, of course, is the rules of the DIFC court. And in my submission, the RDC sets the minimum requirements for proper pleadings. So Rule 17.81 provides the claim form must contain a concise statement of the nature of the claim. Rule 17.171 provides a similar thing with respect to the particulars. And crucially, 17.44 provides that any legislative provision on which an allegation is based must be clearly identified and the basis of its application explained. This is important because specific legislative provisions must be pleaded, and not only that, it must be explained how the provision applies. And if that's not done, the particulars of claim are defective and the claim has not been properly brought. And this is not a technicality or a procedural argument. It's a fundamental matter of fairness. I've referred in my skeleton argument to the case of Towler and Wills, and I just want to take you to a quote from that at page 585 of the bundle.
I follow.
585 at the bottom of the page, paragraph 18. The purpose of a pleading or statement of case is to inform the other party what the case is that is being brought against them. It's necessary the other party understands the case which is being brought against him, so he may plead to it in response, disclose those of his documents which are relevant to that case, and prepare the witness statements in support of the defence. And then over the page, paragraph 19, it's not fair and just that the defendant cannot be sure of the case he has to meet. It may well be that with appropriate legal advice, the claimant could have pleaded a concise, clear and particularised case against the defendant, but that has not been done. If the amended particulars of claim are not struck out, there's a very real risk that unnecessary expense will be incurred by the defendant in preparing to defend allegations which are not pursued, that he will be impeded in defence of the allegations which are pursued, and the court will not be sure of the case which it must decide. And in my submission, this is an important point in this case. The claimant's particulars are not clear or coherent, and the defendant isn't sure of the case which is required to meet. In my skeleton argument, I've referred to two decisions in the DIFC context, the cases of Nessim and Nadia and Nancy and Narcissa, which I'm sure you're familiar with. I don't propose to take you to the relevant passages now, but I say it's a similar sentiment expressed in those cases. The DIFC case, which I would propose to take you to briefly, is the immediate judgment decision in the case of Mahmood and SCB. And we can find the relevant passages at page 575 of the bundle.
Yes.
Page 575 of the bundle, this was a judgment of Justice Roger Giles. And we can see at paragraph 13, the 5th line down, the judge said the pleading was manifestly bad, lumping together 3 categories of express term, implied term, and statutory term, and doing so without any particulars or other explanation of their respective sources. So what was said there is you can't just lump together different types of contractual term, express or implied or statutory, because what you can see at paragraph 11 of that judgment is the actual pleadings from the particulars of claim there, the implied and or express and or statutory terms, and there's a list of 5 terms which were pleaded in the particulars, and this was said to be bad because it didn't distinguish between which was express, which was implied, which was statutory. This is different from the case which you have before you, because we don't even have a list of any terms. All the claimant has said is that he's relying on express and implied terms of the contract without saying what express or implied terms he's relying on. And the next point I'd wish to draw out from this is over the page at 576 of the bundle. We can see at paragraph 16, this is in relation to a whistleblowing claim that was brought under the operating law. And the relevant part of the particulars are quoted there. And at paragraph 17, it said, this was also a manifestly bad pleading. And then the third sentence, nowhere was it pleaded or particularized what provision or what laws or regulations, according to reasonable suspicion, had been or may have been contravened, the provisions being a necessary element in satisfying the disclosure information specified in Article 64(2). So the judge was saying the problem with the claimant's pleading in that case is you haven't pleaded or particularized what provision or law is being relied upon. From this, I suggest you can draw the principle that a pleading is bad where it fails to identify the relevant statutory provisions which have allegedly been breached. In my submission, that's an obvious point. It's the basics of pleading. But I'm relying on this decision just to show that Justice Roger Giles reached the same conclusion I'm inviting to you to reach in this case. Turning to strikeout itself, the relevant rule is at 4.16.1 of the RDC, and it's that the statement of case discloses no reasonable grounds for bringing or defending the claim. The first point which I wish to draw out in relation to authorities is at page 350 of the bundle. Page 350 of the bundle is a decision in DIFC Authority and Al-Shaikh. And this was actually a decision of yours, so you may be familiar with it. But over the page 351 of the bundle, paragraph 4, the claimant failed to address any reasonable grounds or explain on what basis she has any rights to the claim brought against DIFCA. As no cause of action has been established by her, this court is required to strike out her claim according to Article 4.16. And in my submission, that's the right approach. If a claim discloses no reasonable grounds, the court is required to strike it out. The next decision I just want to take you to is at page 570 of the bundle. It's a decision in 570.
Yes.
Paragraph 24. It's a decision in RADA Training LLC and Wealthbridge Trading Crude Oil. So paragraph 24 It's written, now turning to the application for strikeout of the claim against the second defendant. In the third sentence, the purpose of a pleading is to set out a party's case so that the issues in dispute which require determination by the court are clear. Paragraph 8.3.1 does not set out the basis of any breach of contract and lacks clarity. Particulars of claim does not meet the requirements of Part 17 of the RDC. It would be an injustice to the defending party for the court to allow a case that is not properly pleaded to proceed to trial, where the defending party may not have understood the issue to be live. The particulars of claim remain as they stand, and the claimant has not sought to amend the claim the same, and therefore the application was granted. And that's an important point here. The claimant has not made an application to amend his pleadings. No draft particulars of claim is before you. The claimant has been on notice since the defence was filed that the defendant intended to strike out the claim, and no attempt has been made to remedy the deficiencies. And the next decision I want to refer you to is at page 330 of the bundle.
You said 230?
330.
So, yes.
330.
I see.
Now, this is the decision in First Middle East Distribution DMCC and Orange Chameleon. This is another of your decisions, so you may be familiar with it. But at page 330, at the bottom of the page, I just want to take you to paragraph 48. The context of the claim was that a party's claim had been transferred from the SCT back up to the CFI. And in that context, they'd then served an amended particulars of claim. And the defendant was seeking to strike out those amended particulars of claim on the basis that they weren't allowed under the rules of the RDC to produce an amended particulars on transfer, and that they had not used the court process properly. And really, the facts in that had the flavour of the defendant taking a procedural or a technical point to seek to strike out particulars of claim when they weren't really prejudiced in any way by the service of these particulars. And what you said at paragraph 48 is that the court uses the power to strike out a statement of claim sparingly. Strikeout orders are an order of last resort. Even where a party's case is defective or there's been non-compliance with the RDC, the court will first look to respond to those issues by means of applying other mechanisms to cure or fix any irregularities. The defendant doesn't dispute that the power of strikeout should be used sparingly and that the court should look at alternative mechanisms, but what those alternative mechanisms are must be viewed in context. In this case, any defects in pleading could only be cured by amendment of the pleadings to produce a valid and properly pleaded cause of action. Now, in this First Middle East case, you had an amendment application before you. You had draft particulars of claim. And in this case, you don't have either. And indeed, the claimant maintains that his claim is properly pleaded, and therefore he's not applied to amend. The next authority I'll just take you to briefly is at page 301 of the bundle. And it's the Gulf Petrochem case against PetroChina International. 301.
Amen.
And this just sets out the stages of the approach which I say you should take. So paragraph 98. At the hearing of the application, the parties address whether the particulars of claim disclose a reasonable ground. For the reasons stated earlier, the particulars of claim disclosed no reasonable ground for bringing the claim, so should be struck out. So that's the first stage. Look at the particulars. Are there reasonable grounds to bring the claim? If not, strike out. Then paragraph 99, rule 4.17 provides when the court strikes out a statement of case, it may make any consequential order it considers appropriate. So it may order that the claim be dismissed, or it may permit the claimant to replead. And then paragraph 100, it is not appropriate to permit the claimant to replead its statement of case against PetroChina. Neither the claim form, the particulars of court, or the evidence before the court advances a reasonable claim. Despite having been given adequate opportunity, counsel for the claimant did not articulate the claimant's case against PetroChina Middle East. And therefore, the appropriate order is that the claim should be dismissed. And I say that's exactly the approach you should take here. When you're asking, should the claimant be permitted to replead, Your Honour, you need to decide if the claimant has advanced a reasonable claim, either in the particulars, in the evidence before you, or in submissions. If the claimant is saying he should be permitted to replead, the claimant's counsel should be expected to articulate a claim with reasonable prospects. And if claimant's counsel can't do that in oral submissions, then he should not be allowed to replead his claim, and the claim should be dismissed. The final point I want to make on authorities is in relation to limitation. And this only arises if the claimant seeks to articulate new claims which aren't pleaded. And I've dealt with this in more detail in my skeleton argument, but just very briefly, for a non-discrimination claim under the DIFC employment law, the limitation period is 6 months after termination. And it's relevant here because termination was the 24th of January 2025. And so the limitation period expired on the 23rd of July 2025. So any new claims sought to be introduced now or later would be out of time, and that limitation period is strict. And an authority on this point is the case of Abdel Salam and Expresso, and that's the principle can be found at page 556 of the bundle. Page 556, at the bottom of the page, paragraph 54, the final sentence. If therefore an amendment was needed to include new facts in a pleading to give rise to a different cause of action, and that cause of action was already time barred, the court would proceed on the basis that the new claim had no realistic prospect of success. In those circumstances, the amendment would not be allowed. Now, as to what a new claim is, there's some very helpful comments over the page at paragraph 56. However, the claim is undoubtedly founded on a statutory provision, namely Article 18.2. And then 5 lines down, the essential question is therefore whether or not a claim for a penalty under Article 18.2 is a statutory cause of action which require it to be pleaded. Historically, lower courts such as the STC have disallowed such claims where they've not been pleaded. As a matter of principle, it appears to me it's necessary to plead the fact that sums were owing under the Agreement 3 and remain unpaid. It seems to me that it's necessary to plead the relevant article, which is an essential part of the cause of action. Without such a plea, no cause of action under Article 18.2 has been pleaded. It's a statutory right which may be claimed and pleaded, to which limitation provisions apply. And therefore, by not pleading the point, you're out of time, limitation applies. And this is a simple matter of the facts may be pleaded, but you haven't pleaded the relevant article. And that's enough to engage limitation.
What you say, even if the cause of action has been pleaded, Mr. Thomason, you said further clarity or further particularization over the cause of action won't cure the deficiency, and that's pleading. Or they will be subject of limitation.
Well, no, we're saying that the cause of action, which is the legislative provision, has not been pleaded. So if the claimant were to seek to plead exactly what legislative provision is relied upon, that would be introducing a new cause of action, and therefore limitation applies. If the claimant had pleaded a proper cause of action by reference to legislative provision, and it was just a matter of getting some further particulars or further detail, the defendant wouldn't be here. It would have been a matter cured by further information. But this is a case where causes of action have not been properly pleaded, and therefore it's not that it could be cured by further information. So dealing first with the termination claim.
Yes, please.
On the first point, as to whether or not the particulars of claim is defective, the section on termination, which is at page 21 of the bundle, does not plead what provision of the DIFC employment law is breached. The only time an article in relation to termination is mentioned is paragraph 57, which is on page 28. Page 28 of the bundle, paragraph 57, defendant's failure to issue a valid termination letter represent a flagrant violation of Article 62. But no specific subsection is pleaded, doesn't specify how Article 62 was breached. We say the pleading in respect of the termination claim is manifestly bad. So the question is, well, and we say therefore it should be struck out. The question is, how should the court respond? Dismiss the claim or allow the claimant to replead? So just dealing with Article 62, I said I would come back to it. That's at page 382 of the bundle.
So you said they are bleeding the article here, 62, but there is no specific incident is referred to in this case. That what you said?
Well, if we look at page,
but I think I recall the incident is mentioned in somewhere else in this article for claims.
Yes, but if we look at page 382 of the bundle, which is Article 62.
382, you mean? Yes.
Yes. So Article 62. Article 62 has 6 different subsections, right, which all say different things. You need to specify which subsection you say has been breached and how, or else the defendant has no idea what is being alleged in relation to Article 62. Now, what Article 62 is about is the heading is minimum notice periods. And we can see Article 62(1), an employer or an employee may terminate employment without cause in accordance with this article. So this is not a case where the claimant was terminated for a reason or with cause. It's not a case where the defendant has to establish there was a proper cause for termination, because there doesn't need to be a reason. It's without cause. And then Article 62.
See, I'll give you a hypothetical question. If someone says, well, there were a discrimination under Article 62, for example, so, and he did not refer to what subsection of Article 62, would that be sufficient?
Say the example again. Sorry.
Well, a discrimination case or certain case, and he referred to that certain incident, and then said that considered to be a violation of Article 62 of the employment law, and then without mentioning what sub-paragraph of Article 62 would not be sufficient. As I said, she said discrimination under Article 62, and did not mention what subsection of Article 62 would that still be sufficient.
Well, I would say that discrimination doesn't come within Article 62. Discrimination, discrimination is within a different article. And if someone had said that in pleadings, I would say, I have no idea how you're saying Article 62 is breached, and therefore your pleading is defective. All Article 62 says, so we've got Article 62, subsection 2, the written notice required to be given by an employer or employee to terminate the employee's employment shall not be less than. And then there are 3 subsections specifying minimum periods of notice. And so in this case, the claimant started work in December 2021 and stopped in January 2025. So his minimum period of notice comes within subsection B. And that is a minimum period of 30 days. So Article 62, 2b requires a minimum notice of 30 days. Now, you mentioned earlier that there's a dispute about exactly when the claimant's termination letter was received. The defendant says it was the 25th of October. Claimant says 11th of November. Even if the claimant's case is taken to be true, 11th of November, the minimum notice was 30 days, but the claimant's employment terminated on the 25th of January. The minimum notice required to be given by Article 62 2b was given. There is no plausible breach of Article 62 2b. Now, it's really hard to know exactly what the claimant is saying is in breach of Article 62. At page 7 of his skeleton argument, it said that the Article 62 wrongful termination is based on an absence of written reasons / consultation and fabrication of acknowledgement of resignation. But Article 62 doesn't require written reasons. It doesn't require consultation. And the claimant hasn't identified where Article 62 requires this, because Article 62 doesn't require it. If I can just take you to another paragraph in the claimant's skeleton argument.
Yes.
Have you got the claimant's skeleton in front of you?
Yes.
Page 7.
Page
7, paragraph 33. Have you got paragraph 33?
I got it, yes.
So this is under a heading of wrongful termination. And we can see the second last line. It said, Article 62, brackets 3, mandates that written reasons be given at the time of termination. And Article 62.4 requires consultation. But going back to Article 62.3, it doesn't say that written reasons must be given at the time. It says Article 62.2 should not prevent an employer and employee from agreeing to a longer notice period. That's all it says. And as for Article 62.4, it's about payment in lieu of wages, and it requires an employer and employee to agree to do a payment in lieu of wages. But that's not what happened here. The claimant was paid throughout his notice period. The claimant's submissions in his skeleton argument on written reasons and consultation with reference to Article 62 make no sense. And what's even stranger is it purports to quote from Article 62.3 the words at the time, but those words don't appear in Article 62.3. In my submission, this should give the court grave concerns around whether the claimant can be trusted to replead a coherent claim when the terms of Article 62 are cited in this incorrect and misleading manner. So in my submission, the claimant hasn't articulated in his submissions any breach of Article 62 which has reasonable prospects of success. And therefore the appropriate relief is that the claim should be dismissed. Turning then to victimization, unless I can help you any more on termination.
No, move on, please.
I'm going to start with the statute in relation to victimization. So that's page 379 of the bundle. Page 379 at the bottom of the page, Article 60, victimization. Subsection 1, it just says employer must not victimize. And subsection 2, this is where the key elements of the cause of action are set out. An employer victimizes an employee if it subjects the employee to a detriment or dismisses him, and then importantly, because the employee does a protected act, or the employer believes the employee has done or may do a protected act. And then it continues to define what a protected act is. So a protected act is bringing proceedings, so bringing a claim to the CFI, giving evidence or information in connection with proceedings, doing any other thing for the purposes of or connection with this Part 9, or making an allegation that the employer or another person has contravened Part 9. So the key elements are you need to have a protected act in relation to a specific legislative provision, and you need to say which provision you're bringing it under. You need to have some kind of detriment or dismissal. And the key to victimization is that this detriment or dismissal must be done because of the protected act. I've referred to the decision of the trial judge in the Mahmood and SCB case in my skeleton argument, and I'm going to take you to it now, if I may, because I think it's helpful on exactly what this causal connection, what this because means. The trial judge in that case was Chief Justice Wayne Martin, and if I can ask you to turn to page 479 of the bundle, please.
479?
Yes.
Right.
479, we can see the heading of victimization just above paragraph 61.
I see that.
In paragraph 63, it said, the causal connection between the imposition of a detriment or dismissal and the protected act is expressed in terms of because, with the consequences that similar principles of causation embedded within Article 59 are also embedded within Article 60. So it's saying the meaning of because is the same as because in discrimination. So I'll just show you what because in Article 59 means. If you could turn to page 477 of the bundle, please.
Yes.
Paragraph 45. The causative connection required by the provisions of Article 59 means that the contravention of this article is not established by merely showing an employee has suffered a detriment in the course of their employment. What must be established is that the employee suffered a greater detriment than that which would have been suffered by a comparator who did not possess a protected characteristic because of or on grounds of the protected characteristic. And then at paragraph 48, there's a quote from a judgment of the UK Supreme Court. And to be within this section, the less favourable treatment must be on racial grounds. Thus, in every case, it is necessary to inquire why the complainant received the less favourable treatment. And then it continues 2 sentences along, save in obvious cases, answering the crucial question will call for some consideration of the mental processes of the alleged discriminator. So what it's saying is, going back to victimization, when something's been done to a claimant, a detriment or a dismissal, you need to inquire, the court will need to inquire, why did the person dismiss them? Look at their mental processes. Did they do it because of a protected act? Just as a matter of logic, a person can't do something because of a protected act unless that protected act has already happened or you know about it. So in my submission, that the bare minimum of a pleading for victimization must include what the alleged detriment or detriments are, what the alleged protected act is, and that the detriment or dismissal was done because of a protected act. And that needs to be by reference to the relevant subsections of Article 60. Now, in my submission, the claimant's particulars of claim doesn't plead a single protected act anywhere. So paragraph 17 of the bundle. Paragraph 17, page 17, paragraph 15. Under Article 61, victimization is prohibited. Defendant's failure to provide fair compensation, combined with its campaign of harassment and exclusion constitutes a direct violation by increasing his workload, etc. There's no reference to any protected act there. Not said that anything was done because he did a protected act. And that's a crucial failing. You can't pursue victimization if there's no protected act pleading. I won't take you to the other paragraphs of the particulars of claim, but they are paragraphs 23, 37, 54, and 60. All of them allege victimization using the word, but fail to plead any protected act, any causal connection between a detriment and protected act, or even to clearly identify what the detriments are. In my submission, the pleading is manifestly bad and must be struck out. And as to the appropriate relief, the defendant's position is that the claim should be dismissed. He should not be permitted to replead because he's been given every opportunity to articulate a coherent claim and has failed to do so. Looking at what the claimant said in his evidence in response to this application, page 625 of the bundle. 625, please. Right at the bottom of page 625, paragraph 20, it said, protected act equals raising statutory grievance on 11th of November 2024. That is not pleaded anywhere in the particulars as a protected act, but okay, we'll use that. Then it said the detriment is removal from group emails, isolation, and final dismissal on the 25th of October 2024. It's then said causation of particulars pleaded at minimum capable of amendment. It's completely wrong to say this was pleaded. It's not pleaded. And the court should be troubled by the submission that the protected act and causation have been pleaded, because they're simply not. Now, as to the substance of what's said here, for a victimization claim to succeed, the detriment must be because of the protected act. So the claimant was removed from group emails, isolated and dismissed on the 25th of October because 2 weeks later he filed a grievance. That cannot possibly work as a claim, because the legal notice on the 11th of November did not exist when these things happened. The decision makers didn't know about the alleged protected act when they chose to dismiss, and can't have known because it didn't happen. And for that reason, this claim here has no reasonable prospects of success. You can't have a protected, if you're relying on a protected act, which you've done, that cannot have taken place after the alleged detriments as a matter of logic. And because the claimant has not articulated a claim with any reasonable prospects, the appropriate relief is the claim should be dismissed. Turning to the discrimination claim, unless I can assist you further with the victimization.
Now move on, please.
Article 59, page 378 of the bundle.
Reference again.
378.
Yes.
Article 59 is a complicated and technical provision, and I'll take you through it. Subsection 1, an employer must not discriminate against an employee regarding employment or any term or condition of employment on the grounds of the employees, and then 8 different things are listed: sex, marital status, race, nationality. These are the grounds at the core of discrimination. And it must be a ground of the claimants. So you're talking about discrimination because the claimant is a man. You're talking about discrimination on the ground that a claimant is pregnant. It has to be tied to one of these subsections, subsection 1. And a necessary corollary of that is it's for the claimant to say which prohibited ground is relied upon and why it's relied upon. So if a claimant is pleading a claim and wants to rely on sex because they're a woman, they need to say, I am a woman and I rely on the prohibited ground of sex. It's simple, but it has to be done. And this is completely absent from the claimant's particulars of claim. No attempt is made anywhere to define any prohibited ground. Article 59, subsection 2, then contains 4 different and distinct types of discrimination. So the first at subsection A, an employee is treated less favorably than another is or would be treated in the same circumstances or put at a disadvantage not faced by others because of a prohibited ground. So this is similar to the causal connection required in discrimination. It's said that someone did something because of someone's sex or their race. Subsection B, a provision, criterion, or practice is applied to an employee which is discriminatory. Subsection B links then into subsection 4, defining how a provision, criterion, or practice is discriminatory. I don't think that this particular subsection is an issue in the claimant's claim. This is a kind of more of an indirect discrimination claim. You'd need to plead what provision or criterion or practice you're relying upon and how it disadvantages a group. I'm not going to go into detail on this one because I really don't think this is an issue here. Then we go to C under subsection 2. An employer engages in unwanted treatment or conduct related to one of the prohibited grounds, which has the purpose or effect of creating intimidating, hostile, degrading, humiliating, or offensive workplace for an employee or violates their dignity. So the key to this provision is there has to be unwanted treatment. You need to plead what that unwanted treatment is. It has to be related to a prohibited ground. So you need to say which prohibited ground it's apparently related to. And then it has to have a purpose or effect of creating this particular environment or violating dignity. And you really need to plead, are you relying on the purpose or the effect? And then finally, subsection D here, it says Article 59(8)(b) or D applies. This is about disability discrimination, which again, I don't think the claimant is relying on here, so I'm not going to go into in detail. We're really looking at the 2 distinct causes of action at subparagraphs A and C. And in my submission, A and C, they're distinct causes of action. They have distinct tests, and the relevant subsection must be distinctly pleaded, and it must be explained how the claimant satisfies the test. And in my submission, the claimant's particulars of claim fails in all respects. The claimant has failed to identify which subsection of Article 59 is alleged to have been breached. It's not sufficient to refer to Article 59 in the round, because Article 59 contains multiple specific and distinct types of discrimination. The claimant also fails to identify clearly what treatment is alleged to have occurred and what is relied upon as acts of discrimination. He's failed to plead any protected ground. And of course, therefore, he's failed to plead any causal connection between a protected ground and any alleged detriment. Discrimination is very serious. It's a very serious allegation to say that someone treated you less favorably because of, say, your race. And it must be properly pleaded because the defendant needs to have the opportunity to defend itself, and the court needs to know what it's being asked to determine. So I'll just show you how this traces through into the particulars of claim. Page 18 of the bundle. Page 18, paragraph 20. There's a long paragraph. And then towards the end, it said, these actions not only violated the claimant's contractual rights and disrupted his ability, but constituted a direct breach of Article 59(2)(a), as they created a hostile, degrading, and intimidating workplace environment. This mixes up two different subsections of Article 59.2. Subsection A was about less favourable treatment because of a prohibited ground. Article 59.2c is about a hostile, degrading, and intimidating workplace environment. So this pleading merges and mixes up two distinct subsections. So even though a subsection is referred to, it's referred to wrongly. It's completely unclear which is meant to be relied upon. On top of that, of course, no prohibited ground is pleaded. There's no reference to any prohibited ground. Detriments aren't clearly identified. Defendant has no idea what case it has to meet. I'm not going to take you to every paragraph in which discrimination is purportedly pleaded, but they all suffer from the same problems. Relevant paragraphs appear to be paragraph 23, 24, 50, and 55. None of them attempt to plead the necessary elements of a claim. We say it's a bad pleading, fails to plead to the relevant statutory provision, breaches RDC 17.44 and all of the authorities to which I've referred on the importance of pleadings. So the question for you is the appropriate relief. Should you dismiss the claims, or can the claimant satisfy you that he's likely to be able to articulate a claim with reasonable prospects? So just looking at the way the claimants responded to this application, page 626 of the bundle, please.
Yes.
Page 626, paragraph 21. It said protected grounds pleaded. Now that's completely incorrect because no protected grounds are pleaded. And if the claimant is to maintain the submission that he's pleaded protected grounds, he needs to identify which paragraphs of the particulars he's relying on. He's not sought to justify that submission in this document. And it continues, remarks pleaded with dates, but that's completely wrong. No dates are provided in the particulars, and if he is relying on particular dates, then he needs to identify which paragraphs he's referring to, because the defendant does not know. The next way in which the claimant has put his case is in the skeleton argument. So if I can just take you to his skeleton argument, please. Paragraph 38.
38.
Paragraph 38, it says the particulars of claim pleads two protected characteristics, French/Maghreb origin and religious observance during Ramadan. I think you'll know my first point, which is that no, the particulars of claim doesn't plead to protected characteristics. And the claimant needs to say where these apparently pleaded if he maintains that submission. Religious observance during Ramadan does not appear to be a prohibited ground. The claimant needs to explain how that falls within Article 59.1. And indeed, French/Maghreb origin, it's unclear whether he's trying to rely on both combined or separately. It needs to be specified what exactly he's relying on. And then he continues, detriments pleaded include, and then there's 1, 2, 3, 4 matters mentioned. But he's failed to identify what exactly are the detriments. Crucially, which subsection of Article 59.2 is engaged? How is that subsection engaged? And how can it be said that certain acts are said to be done because of a protected ground or related to a protected ground? Necessary elements of a claim are not set out in this document or anywhere else. So the question for you, Judge, is can the court be satisfied that the claimant should be given a chance to replead? Has he shown that he can articulate a claim with reasonable prospects? In my submission on the basis of the documents we've seen, the answer has to be no. If the claimant wants to maintain his position, he should be allowed to pursue a discrimination claim. His counsel should be expected in oral submissions to explain in detail which subsection is relied upon, what acts are relied upon, what prohibited grounds are relied upon, how are the elements of the relevant subsection satisfied, and in what way are the detriments said to be because of or related to the prohibited ground. Unlike the usual case, particularly in a serious and complicated claim of discrimination, the claimant has not provided an amended particulars of claim for the defendant to look at or for the court to review. There's no application to amend. We say the defendant has acted reasonably throughout. He's considered with each document provided by the claimant whether an arguable claim has been disclosed and given the claimant every opportunity to articulate a case, but the claimant has failed to do so. So as matters stand, the appropriate relief should be dismissal. Finally, I'll deal with the express and implied terms claim, and I'm close to the end of submissions. You'll be relieved to know, Your Honour. The defendant has mentioned this possible express and implied terms claim to ensure that all claims were captured, but the pleading on this alleged claim is really thin. The particulars of claim contains no pleading whatsoever of any express or implied terms. There's not a single contractual term pleaded. I can't take you to the particulars of claim to show that because there's nothing to show you. There's no reference to any contractual terms. So this is a case even worse than the Mahmood case, which I took you to earlier, where the claimant had lumped together different types of term. This is a case where no terms are pleaded at all. And the only reason the defendant mentioned this potential claim is because of page 74 of the particulars, page 32. So page 32 of the hearing bundle. Page 32, paragraph 74, subsection A, compensation for financial and emotional harm. Then it's mentioned damages for material breaches of express and implied terms of the employment contract. That's all of the claimant's pleading on breaches of contractual terms. The pleading is so bare that it's unclear if it was actually intended to act as a freestanding claim. But in any event, it stands to be struck out as disclosing no reasonable prospect of success, because you can't plead a claim just by reference to a conclusion without identifying a contractual term, a breach, or what provision of the DIFC employment law has apparently been breached. So the next question for you, because this should be struck out, is the appropriate relief. Should you allow him to replead? Page 597 of the bundle is how the claimant has dealt with this by way of reply. Paragraphs 21 and 22. He's referred to the implied term of trust and confidence. It appears, therefore, that the claimant accepts that pleading of express terms should be struck out, because that's not mentioned. And the reference to implied terms in the plural is now reduced to one implied term, the implied term of mutual trust and confidence. Now it's said at paragraph 22, fabricated resignation and withholding earned leave constitute fundamental breach, and Rogers' witness statement does not address this. It's a strange criticism to make of Mr. Rogers' witness statement in support of the application that it doesn't mention this implied term, because he couldn't address it because the claimant hasn't pleaded this term. So why would he mention it? If the claimant is to pursue an alleged breach of this implied term, it needs to be by way of amendment. And in my submission, he should not be allowed to amend. So first, he says, paragraph 22, the alleged breaches are fabricated resignation and withholding earned leave. Withholding earned leave cannot be a breach of the implied term because the defendant has an express term which expressly permitted it to require him to take his annual leave during his garden leave. He didn't withhold any earned leave because he used it all. This is the immediate judgment application all over again. Because the defendant gets immediate judgment in my submission on that claim, this doesn't work as an alleged breach of the implied term. The second point I would make is that the implied term of mutual trust and confidence cannot be relied upon in the context of termination. And that is what the claimant is purporting to do here. And I refer to the judgment in Hannah al-Hertz in support of that proposition, which is at page 450 of the bundle. Page 450, paragraph 115.
Yes.
Even as an incident of the employment relationship, an implied term must be consistent with and yields to the express terms of the employment contract. And then the final sentence, the employment law comprehensively regulated contract of employment in the DIFC, but it has not been thought appropriate to regulate a contractual power of termination by notions of mutual trust and confidence, good faith, or reasonableness. There is no legislative basis in the DIFC for fettering such a power. Rather, the indication is it should not be fettered. So this implied term doesn't bite in relation to matters of termination. There's other relevant comments continued at paragraph 116 to 118 of this judgment, but I'm not going to take you through them now. The third reason why I say you shouldn't allow the claimant to amend to introduce this implied term of mutual trust and confidence is that this articulated claim does not even make sense. The claimant's claims are all brought under the DIFC employment law. The claimant hasn't identified what provision of the DIFC employment law was breached, and that is fatal. And the final point to make is that any new claim introduced now would be out of time. The claimant didn't plead a breach of the implied term of mutual trust and confidence. No cause of action was pleaded. Limitation period in the DIFC employment law is 6 months from termination. That was the 24th of July 2025. And any proposed amendment to introduce a claim under the DIFC employment law would be time barred. And therefore, any proposed amendment has no reasonable prospect of success. And so the appropriate relief is dismissal. The final point I want to make, and I will be brief on this, is just to highlight another misleading submission from the claimant, which I think does need to be corrected. Paragraph 19 of the claimant's skeleton argument. Paragraph 19, in relation to outstanding disclosure, says, by letter of the 21st of July 2025, defendant acknowledged that core performance bonus and HR files, and then in quotes, will be produced at the case management conference. So the claimant is suggesting that there's a letter which used those words to say the defendant will produce certain documents at the CMC. But the letter from the defendant's solicitors says nothing of the sort. Page 623 of the bundle. Page 623 is the letter. Paragraph 3.1. It's in relation to this strange request to produce which was filed. As to the substance of the RTPs, our client will not be responding at this stage to the schedule of documents. Premature for that process to be undertaken now because standard production has not taken place. As explained above, our client is only obliged to respond to requests to produce provided by our client within the time ordered by the court. No time has been ordered by the court because the CMC has not taken place. Definitely not saying we're going to be producing a load of documents at the CMC. And for the claimant solicitors to contend in skeleton argument that the defendant says something different using quotation marks is highly misleading. And the claimant should be required to explain how such a misleading submission came to be made. And this isn't just, well, I think it's important to correct that, but also it is relevant context for you to consider when considering should the claimant be allowed as a matter of discretion to replead his claim? Can he be trusted to articulate a coherent claim? And for those reasons which I've articulated, the defendant's submission is the particulars should be struck out, claims dismissed, and you should give immediate judgment on the vacation leave claim. As already discussed, I'm not going to address you on costs now because that will follow after your judgment. So unless I can help further, those are my submissions.
Well, thank you very much, Mr. Thompson. I think we've heard enough from you. In regard of Mr. Rana.
Yes, Your Honor.
The court would like to take a short break, and maybe you would like to take a short break too.
Yeah, Your Honor.
And I'm not intending to take a long one, maybe 20 minutes or half an hour. What do you think?
Half an hour would be good, Your Honor. That's
Half
fine.
an hour. Half an hour from now, we'll come, at 1:10 Dubai time.
Perfect.
Good afternoon, all.
Very good afternoon. Thank you, Your Honor, for the break. It was
Yes,
quite
sir.
refreshing.
I hope it's helpful for you.
Thank you.
Yes.
Well, Your Excellency, in my personal opinion, the defendant to strike out an immediate judgment application is quite premature at this stage. The best timing might possibly be after the CMC, or at least after the document production request. But I would not like to take a lot of your time here. I would like just to prove you that the claimant has a real prospect to succeed his claim. And I would like to take you to along with all of this.
Please.
Your Honor, if I take you to page number 27 of the hearing bundle. Para number 54. Line number. And we mentioned that we brought this claim under the DIFC employment law. Categorically, we mentioned Article 59, 60, and 62 are the one to govern all the claims of the claimant. We need to understand, Your Honor, that this claim is an employment matter, not a commercial matter. And DIFC codes, as my learned friend said, is a commercial code, but is also full competent to govern the employment matters. Happens for any employee within the DIFC jurisdiction. So for that, I see that the main dispute between the parties, that the termination letter was not handed over at the time of termination as so pleaded by the defendant. And if the date is there late. So the date itself, either it's 25th or 11th of November, itself is disputed. And my learned friend has not discussed about it in his submission. And why it is important, Your Honor. The first question comes, why it is important? It's because it's a 17 days of the remuneration that an employee, the claimant, who is losing just because of the defendant acted in bad faith and manipulating the facts and lying completely in his submissions as well and in his defense as well. I'd like you to take you to hearing bundle page number 110, para G. Wherein the defense itself have acknowledged that at the same time, on 25th October 2024, Mr. Jaud offered the claimant the opportunity to enter into the...
What paragraph you're reading?
G, Your Honor.
G, yeah.
It says that at the same time, on 25th October 2024, Mr. Jaud offered the claimant the opportunity to enter into the settlement agreement with the defendant, pursuant to which the claimant could resign from his employment rather than be terminated and receive an additional ex gratia payment of 1 month's pay as well as payment for accrued leave not taken during the summer, the settlement offer. Mr. Jaud handed the claimant a hard copy of the settlement agreement, a pre-prepared, I need your attention, Your Honor, acknowledgement of resignation letter, which could be signed by the claimant if he chooses to enter into the settlement agreement. So they prepared themselves without even a resignation on the table with them. And if I take you to the hearing bundle, page number 63, which is the letter itself. And from the beginning, Your Honor, if you are there,
Yes.
it says, in response to your resignation letter dated 25th, 25, 2024, with stamp and signature of the defendant. Now, this is the very crucial fact, Your Honor. The claimant never resigned. How they can present this as a resignation? And we come to this part at the end of we are taking you long to this, why this happened actually. If I take you further, Your Honor, on the hearing bundle, page number 129, para number 9A, where in the witness statement of Mr. Leader, where I say that he is not the first eyewitness, and the facts that he is presented should not be admitted. But he clearly acknowledged in para number 10, the above disputes of facts are not relevant to this application. I mention them really to ensure that I'm presenting the full picture. How he is presenting the full picture? When with this 17 days period of time, an employee is losing his 17 days remuneration. And why they are not relevant to this claim, Your Honor? Because as of now, we are still not sure whether the claimant was terminated on 25th of October or 11th of November. I'll take you further, Your Honor, to this. Hearing bundle, page number 88.
Well, exactly that, because Mr. Roger, I think he is confirming that he is not a witness of fact, whether he's giving witness in support of the strikeout application and the immediate judgment application there, where he has to speak more or less about procedures and legal matters, but he will need to support it with factual, but
these facts are not true. This is
why is that?
Because he says it's not related, and then he says that he has been given the termination letter on 25th by hand. No evidence in defense is produced there, Your Honor.
Then you can easily exclude this. I mean, it's not.
Yes, Your Honor, we can strike this out completely and this, but I will just want to make sure that I present that we have the real prospect to succeed our claim, which is the basis of the defendant to strike out an immediate application, that we don't have a potential here. So I would like to take you to the page number 88 of the hearing bundle as well, Your Honor. And I tell you how I am taking you. In this termination letter, Your Honor, if we go that he has been terminated, if I take you to para number 2 and the second sentence, however, as your managers have previously communicated to you, these efforts have not fully met the bank's expectations. I want you to note this, Your Honor. They did not give any reason for this termination. And if I take you to page hearing bundle 133, page number 133.
While in this page 88, I mean, what paragraph have you been reading?
Sir, page number 88, Your Honor, paragraph 3rd, second sentence. However, starting from however, that they say, as your managers have previously communicated to you, these efforts have not fully met the bank's expectations.
Yeah, why I'm telling you this, Mr. Rana? Well,
yes, Your Honor. For this, that we pleaded that the termination is the breach of Article 62. There where I'm trying to take you, that the defendant pleaded that they terminated the claimant under Article 62(1) of the DFC employment law, which says an employer or an employee may terminate an employee's employment without cause in accordance with this article. But what is here in this pleadings are in front of you, Your Honor.
They're stating a cause, yeah.
Yeah, there is a cause. So there is a complete breach of Article 62. And also, Your Honor, if we go here On page number 133 of the hearing bundle of the defense
I mean, let me know what stating a cause. How would this changes the legal status of the termination?
Because the cause itself, when we will identify, is based on our further claims, which is discrimination, victimization, and also for the immediate judgment on the annual leaves, which the claimant have not taken, will affect it completely. Because now the termination is for the cause, not without the cause.
But yeah, I don't know how you would link this. I mean,
if you just give me, I will take you to this all, and in conclusion, I will for sure convince you, inshallah, that why it is like this.
Because this is mere business. I mean, when he said you didn't meet our expectation, when you read the rest of the paragraph, you could see this is about the business itself.
Yes, Your Honor. So it is there. And they say that it's because he have not been performing business, he's not been generating fees. And I want to take you to the conclusion where he was never supposed to generate fees. It was not his job description against which he has been terminated.
Why that important? Because does they need a cause to terminate him? You just could serve your nervous and that's it, you know. That's the problem with this with the situation here in the DIFC, Mr. Rana.
Well, the cause itself is the harassment and victimization thoroughly on his employment tenure with the defendant, Your Honor. And that was the cause.
1 second.
And when they say that he has been terminated under 62 with employer choice itself, it's wrong because they terminated him with a cause. And the whole arrangement then changed completely.
Yes, please.
I'd like to take you, Your Honor, to Clear Bundle page number 133 of the defense, para B, where the defendants articulate that under Article 62(1) and 2 of the DIS employment law provides that an employer may terminate an employee employment without cause. It is not in dispute between the parties that the defendant provide the claimant with a written notice of termination of his employment, which is disputed. And this termination is not without cause, is with cause. The defendant was not required to provide cause of this termination. The termination was also in accordance with the clause 20.1 of the employment contract. The defendant pleaded that he terminated him without cause, but itself he says that it is due to cause, which I can take you to here bundle page number 96, Your Honor.
Yeah, you say, first of all, this is contradict the termination letter we have just seen before at 88.
Yes, Your Honor.
And then?
And then if I take you to page number 96, para 7E.
Yes.
They themselves mention in defense. The fourth sentence is accordingly denied. The claimant employment was terminated primarily because of performance. These were only concerned about the claimant's behavior, which were into the decisions. So there was a cause, and which was the performance. And now I want to take you to the performance part of the element of the termination. If we go to Your Honor, page number 95 of the bundle. 95. Para 3. Third. In which further on it is narrated. Zoom in middle. Omar had a reasonable good year in T&E.
So what page is that?
Sir, page number 95, Your Honor.
Oh, the previous page. I see.
Yes.
95.
Para third and the statement further on after that, which mentioned that Omar has had a reasonable good year in T&E and has generated connectivity, but however, still no closing/fees. This, Your Honor. And then if I take you to para 7th on the same page, during his employment with the defendant, the claimant did not generate any fees from his own client relationship or business development activities. And if I take you, Your Honor, to page number 97, then just next after it, para C, page number 97. Now, para C.
This is page 5 of the defense, yeah?
Yes.
Yeah.
Go up.
The reason for the offer was, yeah?
Yeah. It's also mentioned for the leave for the whole. Sorry, Your Honor. It's on this. I think I missed the page number probably. For its saying this 97 page number.
As
Sorry, Your
explained
Honor.
in this
Page number
performance
is
review
96.
2023, he had generated no closing fees.
Yes, Your Honor. So, and now if I take you to page number 150. Which is the job description of the claimant himself. 150 and 151. In his job description, there is no element in his job description to generate fees at all. And then the defendant pleaded that he has been terminated due to no fees he generated. So the termination was under Article 63, not under Article 62, which is the breach of Article 62, because that has been used for termination of the claimant by the defendant. And the same has been particularized properly in our particulars of claim. And that also shows that how the defendant have acted in bad faith and violated the DIFC employment law completely, just for his own gains or on purposes, which need to be pleaded further on. And this itself is sufficient reason, Your Honor, to go to the trial. But if we go further to see either this element of his success or performance is relatable or not, or matches his job description, we can go to page number 600, Your Honor, which was part of the exhibit of my reply to the strikeout or immediate judgment application of the defendant. It's his promotion announcement by the defendant. And then what's the argument is there for the defendant? That he has been promoted because he was not performing well. From where in this world, Your Honor, we see that if somebody is not performing well, he been promoted rather than demoted. And then he has not been given any extra remuneration for additional duties that he has been appointed. And then if I take you further on, Your Honor, to page number 601, the just next after it, it clearly shows his bonuses that he received for his performance since 2023. He had this screenshot on the phone when he received old times. He is not in the possession of all the documents since he was an employee and he handed over in the immediate meeting.
Mr. Rana, I'm trying to be very patient with you. I try not to take your time, not to stop you speaking, but putting a professional submission before this court should have an order, okay? You know what's the case against you today. You know what is the application, but before you, first of all, there is an immediate judgment application, okay? Were you supposed to reply to that first, for example? So I don't want you to take any order, but you could but you need to answer all cases against your client in here. There is an immediate judgment application where the defendant said, this is how we're going to deal with it. Then you need to deal with that. You need to tell me why you have a prospect of success in this. What you need to take me through your bleeding, because the attack is against your bleeding itself. The deficiencies is linked with your bleeding, that your bleeding does not make a good case that the court can deal with. That your bleeding does not sufficient to give you a good reason that you should go to trial. What the defendant shows the court the weaknesses in your bleeding that make a deficiencies, which is as a result should not go to trial. Your case is not clear, it's not linked, it's not particularized in a sufficient way that the court and your opponent understand, and it doesn't make an clear legal cause of action. And then this is the kind of case you hear now you're supposed to defend. But would appreciate you trying to take me to different paragraph related to the cause of action. You know what I mean? But I think you're supposed to do something else today.
I understand, Your Honor. I so much want to bring you the same way as I brought you in the first instance to my particulars of claim, where we said that this matter is brought forward in your court, Your Honor, under DIFC employment law. And there is a breach of Article 62 of the employment law by the defendant himself for his termination. And like I said earlier, Your Honor, I'm trying to explain you the real prospect of success of the claimant's claim. And the reason why we are here, that I so much believe that the claimant himself has delayed in submitting his defense, actually, which we requested to file the defense. Certainly, we understand your orders, Your Honor, that we have not been allowed to submit our defense after our application because it has been quite late. And if it had been an opportunity to go to the CMC, might we have been presented our matter in further, more better way to make you understand our claim as well in that regards. But all I'm trying to do here is to show you the real prospect of success and bring you to the whole sequence, what articles has been written in our particulars of claim, which are under the breach by the defendant himself. And if the defendant pleads that our particulars of claim are not properly particularized, then it's certainly not the case. We have learned just right now from the defendant's counsel that he has been successfully understood the claims of the claimant, which has been agreed even in the skeletons. So he have completely understood that part. His concerns that is not pleaded very well. There are multiple factors involved, Your Honor. The lack of evidences, since the claimant is an employee who left all the possession gadgets, emails, access, everything in the meeting. He did not have sufficient evidences as of now. We were looking forward for the document production request so that we could have sufficient evidences to further particularize and add it up further in our particulars of claim, later might be replied to the defense. That was our plan there, Your Honor, but certainly...
Yeah, but we all understand evidence is the next stage. Bleeding comes first, and then evidence come next. And you know that even the court could stand in your side if there is an evidence you could not have access to. First of all, you could ask your opponent for evidence if you think it's in their custody. And if your opponent is in a cooperative with you, you could seek the court protection or the court help. So the court would help you to have that document you think relevant and material to your case that in your opponent custody. But that is the next stage. Well, but you need first to particularize your case. What is you suing for? And what is you suing for is something foreseeable and approachable as well.
Certainly, yes, Your Honor.
And like, yeah, I was expecting you to deal, for example, with the 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 with with the leave case first, with the untaken leave case first, and then with the discrimination next, with the...
Certainly, Your Honor. Actually, the reason why I brought you first on the termination, because when I believe that when I will explain you the termination reason, and we will go to the leave part, it would be easy for me to explain you and to make you understand that why such claim is still valid. And however, if you say, Your Honor, I can take you firstly address the leave part.
What I said, I'm not giving you instruction. I'm not here to tell you how to submit before me. This is your skills and this is up to you. I can't be in one, I can't help and assess one party over the other one, you know.
Thank you so much, Your Honor.
I must remind myself to be impartial completely.
Thank you, Your Honor. So
I'm not here to help you. I'm putting the defendant case against in simple way for you.
No, I understood, Your Honor. Even
I'm trying to remind you the criticism and attack to your submissions. And I said, I'm expecting from you, at the minimum, that the way you're defending the criticism to your particular claim and submission today in a different way.
Understood, Your Honor. Understood. So I will.
And one of the big problems as well, well, the defendant is relying in your conduct not to give you any other chance to either to apply, to re-amend it, or to resubmit anything related to this claim.
We understand, Your Honor, but with all that saying, it's ultimately the claimant should not be prejudiced to his rights to claim all of his claim that he have. And if I bring you to all the particulars of claim after finishing the termination part that I want to do, because this part is important to understand that do we have a real prospectus, then I will take you to my particulars of claim clearly and why we are there.
Then I must be patient and listen to you. Go ahead.
Just a little, Your Honor. Thank you, Your Excellency. So it's almost finished, Your Honor. So that's all. I just wanted to present you with the evidences that the claimant had later when he digged out. The bonus there was on the page number 601, which was given to him for the year 2023. The bank statement justified that on the page number of hearing bundle 602 there of his incentive of bonuses he received. And then on the hearing bundle, page number 604, which is part of our reply to the strikeout application, which the claimant himself has cracked one of the biggest deal. We got it at the news cut because we don't have the evidences as of now in hands. So we presented that. And if, Your Honor, I take last an opportunity on this part and then I'll finish the termination part. Here under page number 6014 and 614.
614.
Yes, Your Honor.
Yes, I'm with you.
In para 3, last sentence, if we see here, Your Honor, it's an email from the defendant himself, which says itself that during the meeting in the second para, Your Honor, during the meeting, we communicated the bank decision, termination of employment contract with Natixis. Therefore, the attached termination letter is dated 24 October. That means it was not ever given, which is, if we go to particulars of claim, completely breach. And this is what we have pleaded. And this is in reply to their strikeout application. Go to the particulars of claim where no termination was given.
So what's the point in here? What you trying to say? I mean, this is an email mentioning a termination letter, and you saying the termination letter will never been communicated.
Yeah, certainly, yes, Your Honor. They say the defendant say in his defense, they have handed over him the termination letter at the meeting. In our particulars of claim, we say he was never handed over. And then this email comes way after. If we go to the date, we see on the email.
This is November 11.
Yeah, November 11. They say that since we communicated, that's why it is dated on this date. It should be the same copy. They should not even to be.
So this is almost 2 weeks.
Almost 2 weeks. So this is what the same we have pleaded in our particulars of claim, Your Honor.
Yeah, okay. I'll continue with you, and let's consider this email itself is the termination, not that letter they're mentioning. How this would change the situation?
The situation changes, Your Honor, this because they pleaded they have terminated him without a cause under Article 62 of the employment law, without a cause. But in all of their defense, they have pleaded that there was a cause, which is Article 63. And now if I take you to the leave part, which is for an immediate judgment to you today, if we go there, Your Honor, the Article 63, page number, just tell me. 2C, Your Honor, expressly say page number. Or Your Honor, I'll take you to the page number, employment law. Do you have in there? Yes. It's on. Sorry, Your Honor, just 1 minute.
Employment law.
You're
referring to employment law?
No, Your Honor, we just finished it.
356.
Yes, Your Honor, 356. Thank you, Your Honor. In Article 63 2C, it says, a payment in lieu of the employee's accrued untaken vacation leave calculated to include in the notice period of the employee would have been required to give to terminate their employment in accordance with the Article 62 of 2. If an employer terminates the employee for a cause pursuant to Article 63(1), the employee shall not be entitled to receive any payment wages in lieu of their notice period, and the employment gratuity must and outstanding vacation leave shall be calculated up to the termination date. So, in this regard, what has been pleaded in defense that he was forced to take his annual leave, which was his entitlement only under Article 62. But under Article 63, C and 3B, it's clearly mentioned that it should all be calculated up and he should not be asked. What my friend have not been addressing it, this annual leave, which was accrued to the claimant, was post-termination.
Have you referred to Article 63 in your submission? I've seen it's 2062, 59, 60, and 62. I can't recall 63. Have you referred to Article 63 in your submission?
In our submission, we said Article 62 is the breach, Your Honor.
Okay, not 3.
Article 62 is the breach by the defendant. We did not articulate it on 63, but it is the breach of 62 because it's not for a cause. It's not without a cause. There is a cause.
Oh, I see.
And the same has been articulated in our particulars of claim. And for the leave part, Your Honor, I want you to take on just little on this. And that's all for the termination part, Your Honor, that I wanted to take your attention on. And now I will address the leave part first, and then we'll go for the last part and how I will show you this. So if you allow me, Your Honor, on the leave part, we see that the accrued leave part has been forced after the termination. It's not before termination. He was placed on garden leave after the termination. The garden leave does not require you to be terminated. That the point need to be understood, Your Honor. Once that employer terminated him, he put him under the garden leave and then he forced him to take his accrued leave. This is completely injustice, Your Honor. We do not in a conflict with the defendant's submission that the employer could not force him to take leave on the garden leave, but not after termination, when he's serving his notice period, then consensus should be there. Why undermining his rights?
And why they cannot do that after termination? Because he's still employee until the final day of the notice of the company, isn't?
Yes, he is, but he is on garden leave, Your Honor. But the consensus should be there. And that's why we refer to Article 27(3) of the employment law.
What 27(3) says? 27(3)?
Yes, Your Honor. An employee is entitled to carry forward accrued but untaken vacation leave into the next vacation leave year of maximum period of 12 months, after which any unused vacation leave shall expire. The same that my learned friend has read it out for you.
Yeah, I've seen that.
Yeah.
This is the carry forward. This is the carry forward principle, yes.
Yes. So it should follow that after termination. And why we are referring this? Because when we go on to the victimization claim of the claimant, this is where it comes, one of the part, that how it has been undermining his rights.
So I don't follow. I really don't follow. I mean,
well, you know, when he has been terminated, he was
yes.
placed on the garden leave. He was an employee. The defendant pleads that they have forced him to take his accrued leave during his garden leave period.
Yeah, my question is as simple as that, because I need to understand why the employer, giving to the fact that the contractual arrangement between parties, that the employer at his sole discretion may ask the employee to take a leave. Yeah. Why they cannot ask him to take the accrued leave during the garden leave?
Yes, Your Honor. I'll let you know, Your Honor. If we go to page number 617.
Six 617, the email, yes.
Yes. Where the defendant said to me that Omar will receive his salary until January 24. In January, we will pay him ex gratia payment, untaken leave, and we will directly pay him the dues for the January. They acknowledged here that they will give. And then in December, this email is on 4th of November. And the letter that has been referred by the defendant counsel is in December, where they say, we force you to take everything and like that.
So this is 4th November. We did say by 4th of November, we have an agreement like the termination occurred, yeah? With cause or without cause, that's another case, yeah?
Yes, you know.
And then later, like December, they said, oh, no, we're not going to pay you untaken leave, but you better utilize it now during your garden leave.
Yes, Your Honor. And
also, my question, you said they cannot do that?
They acknowledge that, Your Honor, already, that they will not do that.
And then they utilize the discretion at later stages, said, oh, we think, no, you better take the leave now.
No, Your Honor, they should not do that. And that's why we are referring to Article 27(3), where the consensus, where an agreement is there already. Leave, which if I take you again to 27(3), which says leave to be carried forward may be agreed between the employer and employee, provided that nothing shall preclude an employee from rolling over at least 5 working days for vacation leave per year. So there should be an agreement, and this was an agreement between the parties.
Okay, and how about the discussion between myself and the defendant counsel that because there is no other year, so you cannot carry forward anything. So we'll go back to the either payment or carry forward or utilizing the.
So there they sent this email, Your Honor, that we will give you.
I see, I make a record of this.
This email on page number 617. 616, sorry, Your Honor. Sorry, 617 is itself.
Yes.
So there was an agreement, Your Honor.
Let's suppose there is no, we don't have this email and there is no agreement. Okay. So the usual course of dealing is that the claimant takes his in lieu of untaken leave, yeah?
Yes, Your Honor.
So even with this email or without it.
With this
But I
email,
said, then they try to make effect of their discretion that, as they said, the contract gives them, and then they ask the claimant to utilize his leave during his garden leave. And you said they cannot change their mind now.
they cannot, because Article 27C, that when they agreed between this, and when they agreed for one thing, they said it supersedes, because it's then after that they terminate him on 11th, since still the termination date is disputed.
So say,
First part.
yeah, I see this point. Yeah, move on, please. Yeah.
Yes, Your Honor. Your Honor, that's for the accrued leave part from my side on this head. The termination I have already discussed. Now I would like you to take you to the pleading part of ourselves, where we have been accused of not properly particularizing our claim, which under relevant articles of law. Certainly, I explained you that we do not have evidences as of now, for which we need to go to the CMC to get the document.
Believe me, see, I'm not worried about evidence. Neither the defendant are worried about evidence at this stage. Believe me, we discussing today is your pleading, your submission.
Yes, Your Honor. I would like you to take you to all the pleadings part where we referred. If we go to page number 17, of hearing bundle, para number 15, we mentioned under Article 61 of the DAS Employment Law 9, victimization was happened. We pleaded well there. And now to prove the victimization, we needed evidences, and we stated the facts that what happened thoroughly. And for that, we had to go. And if I take you further, Your Honor, to page number 18, para number 20, 18.
A second. So paragraph 15 of your particular claim is the first time you sorry, mention victimization, yeah? And refer to Article 60, subparagraph 1, yeah?
Yes, yeah.
So pleaded at.
And then, Your Honor, if I take you to page number 18.
Next page, you see, yes.
Paragraph 20.
Right.
Last fourth line of paragraph 20, where Article 59(2)(a) of the DFC Employment Law has been pleaded, where the behavior of the CEO was contested.
I see.
Yes. If I take you further on, Your Honor, to page number 19 and paragraph number 23, the systematic harassment by current CEO and top management. We refer there Article 59 and 60 of the DIFC employment law. And further on, page number 24, sorry, the para number 24. In the same, we continued with Article 59 particularization is there, Your Honor. And also the words for the harassment that has been used has been addressed in this paragraph. I'm not going through all the paragraphs reading out for you, Your Honor. I'm just trying to explain you how we have particularized every claim in our particular claim. If you want, I can go through, Your Honor, just to save the time that I'm doing this though. If that is fine for you, Your Honor.
Just bear with me, yeah. Doing something. So at this paragraph, at this victimization paragraph, you again mentioning the 59, which is the discrimination paragraph too at the same time, yeah?
Yes, Your Honor. It's against, if I take you to again the particular of the DIFC employment law 59, it's against race, Your Honor. It's referred to Brown, which has been particularized. If we go 59C, it's
where is this? Where is the CEO from?
CEO is from, you don't know, Your Honor.
You don't know?
No, I don't know. Maybe defendant counsel could help us with that. I don't know.
Are they same nationality? Is he the same nationality of the claimant?
With best of my knowledge, no, Your Honor.
No.
No, races, the religions are different. The same has been pleaded in our particular claims for the non-respect of Ramadan. And if we see in the same discrimination, 59G, religion is one of the better. And then also in DIFC employment law, Ramadan timings need to be addressed and accommodated by all the employers. It's part under the DIFC employment law, which has not been respected.
Yeah, I mean, you must have seen Article 60, and you must have heard from the claimant, from the defendant counsel this morning that in order to activate our Article 60 victimization, you need to show that an act has been breached.
Certainly, yes,
not just referring to Article 60, but you need to go beyond that.
Certainly, yes, Your Honor. But right now we refer to the harassment part, discriminatory part, the 59, and victimization. If I just conclude it summarily, yes, for the victimization part, thoroughly we see that during his employment, he has been performing well. I took you to certain documents which prove that he has performing well. He has been awarded with the bonuses, he has been promoted, and yet he has been terminated due to performance. And it's all go through the chain of victimization, for which we requested under being part of this application for the document production, but since it has been contested by the defendant counsel, we have not formally filed that. And we look forward to succeed in this application so that we could go to the CMC and do a procedure further, where all the victimization claim we can prove with all the correspondence and emails and messages that are there in the defendant custody, which proves all of it. But
yeah,
further,
but the act is not part of the evidence. The act we refer to in Article 60 of the employment law. It's not part of evidence exchange that's going to happen during or after the CMC. Your Honor, it's part of the law. That's something you should plead.
If we say, Your Honor, we pleaded that same. On the date of the meeting when the defendants say that he has been terminated and he has been given a handed termination letter itself is victimizing the claimant himself. They say a pre-signed resignation accepted letter to the claimant.
Yeah, this is a breach of what act?
This is victimization, Your Honor.
I see, okay.
For example, Your Honor, if I give you a signed resignation letter to somebody and tell him, okay, give me your resignation, is it not victimization? Is it not harassment? It is a harassment, Your Honor. Either you terminate him or communicate to him that we are planning this. If you want to do this, then do this. But they just throw a resignation letter, acceptance of resignation when there is no resignation. And certainly I cannot demonstrate what happened in that meeting, but thoroughly the claimant itself has faced harassed and victimized in that particular session of the meeting, for which certainly we need further trial to go on to examine the witnesses and to understand what actually happened in that meeting and why thoroughly it have concluded in this way where the claimant has been victimized and harassed. Because that's the conclusion of all the stories during his employment. Because thoroughly when we see around, even we have pleaded the breach of the employment law, nowhere in his time, he does not have any warning letters. He does not have any correspondence have been issued to him where his performance was addressed during his employment matter. Rather than he has been promoted to a new positions, rather than he has been given bonuses during his employment. Certainly, there is set of events that happened to him which resulted in ultimate harassment of accepting a resignation without any resignation on the table. And that act itself, and that's why I say the witness statement of Mr. Roger Lee explained the facts, which he is not even an eyewitness to it. And the claimant should be given an opportunity to examine those facts, at least to the witnesses. It should be produced as the first eyewitnesses, Your Honor, based on an hearsay statement, which is pleaded in response to our claim. And the whole application is based on this particular witness, hearsay witness statement of the solicitor of Mr. Lee. So this is very complicated, Your Honor. This is not straightforward, and I and the claimant have full trust in your court, Your Honor, that we will definitely get the justice from your court. And based on this, we have pursued this order. I understand, Your Honor, since the defendant has outlined some deficiencies in the particulars of claim, we truly undertake, if you believe that there should be some amendments, we will do the amendments. We'll send up the draft if you will believe that it should be there. But however, I can take you to the further particularization if you allow me.
Yeah, please go ahead. Go ahead.
Yeah. In the same, Your Honor, like we referred in page number 26 of the unpaid accrued leave and compensation breach, we referred Article 28 in para number 48. As amended there further on. And then on para number 50, we refer to Article 27 and 28, which we discussed just a couple of minutes back, Your Honor. And then in para 51, we said the breach of Article 19(1)(c). Furthermore, there is the employment law. Mandates of the outstanding amounts related to the accrued vacation leave to be paid within 40 days. The same the defendant counsel has been addressing before. It's all part of the particulars of claim, Your Honor. So nowhere I understand. Further, if I take you, Your Honor, to page number 27, the first para itself says to the Article 19(c). And then if we go further on to the legal reasoning 54, para number 54, we referred Article 59, 60, and 62. There is a breach of Article 62. And then if we go to para number 55, we have particularized with Article 59(2)(c), all the legal reasoning, We further referred it to Article 59.3 in the same para 55. And if we go to para 56, we have particularized with under Article 60, which expressly prohibit victimization. And then, Your Honor, if I take you to page number 28, para number 57, we mentioned failure to issue a termination letter at the material time and its deliberate post facto justification represent a flagrant violation of Article 62. And if I take you further, Your Honor, to page para 58 of the same page, we refer under Article 43.2, the defendant was legally obligated to provide a workplace free from discrimination and victimization. All these claims have been particularized and need to be justified and mandates to go to the trial and further go to the CMC, Your Honor. But that's not all, Your Honor. If I take you further to my relief sought in the last, I've clearly mentioned what we are looking for in our claim. Considering the fact of the case and the situation between the parties, Your Honor, there were lack of evidence in the claim in custody, that's for sure, and I admit that. But particularization was complete there in the particular claim. The relief we are seeking from your court, Your Honor, was stated expressly, and the defendant acknowledged that, and he addressed each and every point. So from my side, Your Honor, our particulars of claim are of sufficient grounds, are properly particularized. Since if the court believes that there should be an amendment to be done to the particular claims, we undertake to do that, Your Honor. But on all of these grounds, Your Honor, I humbly plead to you that this strikeout application must be dismissed and the immediate judgment on the accrued leave part is not justified from the defendant's side on his acknowledgement from the defendant email itself of giving it to the claimant must be sent to the trial and must be struck out on the immediate judgment and must be went to the trial so that properly justified what happened, why they acknowledged that, and why they later terminated it. And still, there is the date of termination is not disputed, which has been properly particularized in our particulars of claim, Your Honor. In reply to this strikeout application, there is still a 17 days unknown whether the termination was on 25th, on 11th. We cannot rely on the facts of a hearsay witness statement of Mr. Lee. We need to examine them. And this case at this stage certainly mandates to go for the CMC and for the further trial, Your Honor, because the claimant needs to have the documents on board to further adjudicate his case, plea in much more better way after the document production procedure, and get his right for the justice in your court, Your Honor. That's all from my side, Your Honor. I rest my case to your wisdom, and that's all.
Thank you very much, Mr. Rana.
Thank you.
I'll ask Mr. Thomason if he would like to say anything.
Yes, I will be. Sorry, I will be brief in reply. I only have a small number of points I just want to address you on. The first point, I want to reply on a point made about Article 62 of the DIFC employment law. And it was said that because the defendant did have a cause, it couldn't be a breach of Article 62. I'm not going to spend long on this, but we say it's not a good submission. Article 62 doesn't prohibit an employer from having a reason for dismissing, of course. And just to explain, of course, Article 63, page 382 of the bundle, does provide for termination for cause, but the difference with termination for cause is that it can be with immediate effect. You don't get your notice pay. That's not what we tried to do. It can be without cause as long as you provide written notice of the minimum period. it's not a good submission, that just because we had a reason, it can't be without cause, or else no one could come within Article 62 because there's always a reason for dismissing someone. The second point I want to address you on, I don't think this email goes anywhere anyway, but page 617 of the bundle.
Yeah, I recall that.
It's in relation to the annual leave claim. Right at the bottom of page 617, we can see the header of the email. So it's from the claimant's representative on the 4th of November. The subject of the email is clarification on settlement agreement terms for our client. And then we see over the page at 618, the content of Mr. Rana's email. So it's to the defendant's HR partner. And it says, you know, we're writing on behalf of Mr. Ben Hallam. Recently reviewed a settlement agreement that's been provided. We want to see clarification regarding the total settlement sum in terms of disbursements. And we can see specifically it's asked, point 1, what the total amount is, what it comprises, and
so is this without prejudice?
Sorry?
Is this without prejudice?
I don't think any of it was labeled without prejudice.
Oh.
It was negotiations conducted on an open basis, but it was to discuss a possible settlement. The respondent, the defendant had produced a settlement agreement that said, well, we'll pay you your notice, we'll pay an ex gratia payment, and we'll pay
second
your
offer,
leave.
you mean? Second offer. So.
Yeah, it was an offer. It was an offer. And Mr. Rana was writing to say, can we clarify what are the terms of that offer? And then we have the reply at 617. Omar will receive his salary until the 24th of January. In January, we'll pay the ex gratia payment. So that's one of the parts of the settlement offer, untaken leave, and we'll pay for the dues. So this email is not saying we promise we will always pay you that annual leave. It was, if you accept the settlement offer, we will pay you that. And if you trace the email all the way through, we get to page 614. Page 614, there's an email on the 11th of November from the defendant's head of human resources. And the second paragraph, I kindly request you sign the settlement agreement and termination letter by Wednesday the 13th. Please be aware, if you don't receive your agreement to the new terms, we will regrettably need to revert to the terms required by law. The claimant didn't accept this offer, and therefore the parties revert back to the contractual terms and the terms required by law. So to suggest that there was somehow an agreement about the parties about how annual leave was used is a completely misleading interpretation of this email, which was all done in the context of discussion about settlement terms. We say this provides no basis to say that there was some sort of agreement that annual leave would be paid on termination. This matter of the settlement offer and what it contained is all ventilated in the defence. It's explained that this was a parallel process going on, but it led nowhere because the claimant didn't accept the terms. And the final point, which I would make, is just in relation to the claimant's particulars of claim. And there's 2 points I'd make in relation to his particulars. The first is in relation to strikeout, the claimant's counsel took you through the section of the particulars of claim in relation to annual leave to say it's pleaded, we've referred to the relevant articles, etc. We agree. We're not applying to strike out the annual leave claim. We're asking for immediate judgment in respect to that claim. It's everything else. And ultimately,
and he took me through paragraph 55 and 56, where he said the rest of the claim are pleaded.
Yes, exactly. He relied on those paragraphs, and I'm not going to repeat my submissions in detail. I think you have the point that we say that constituent elements of a claim aren't pleaded, and we say the fact that the claimant is now making the submission that the claim is properly pleaded only serves to demonstrate that the claimant cannot be trusted or relied upon to replead his claim and formulate a claim with reasonable prospects. The court can have no faith that there is any value in allowing the claimant to replead his claim.
I think the claimant thinks his part of a claim is a really good one, and unless the court see otherwise, the court should allow him to amend it.
Yes, you'll have your own view on whether he's properly pleaded. We say it is not properly pleaded. The fact that the claimant thinks it's a well-pleaded claim and there's nothing wrong with it really only serves to emphasize the fact that the relief should be that the claims are dismissed. He shouldn't be allowed to replead. And what you sometimes have on an application to strike out is the defendant applies to strike out, the claimant looks carefully at their pleadings and thinks, or instructs counsel for the hearing, and then they realize, oh yeah, we do have problems. They come to the hearing with the tail between their legs and say, we accept there's problems, but we can fix it. This is how we'll fix it. We'll do these things. Sometimes they might have a draft. Well, normally you'd expect a draft of the particulars. This is how we're going to fix it. This is what we'll do. Give us the chance. And in that case, the court, you know, if a properly formulated claim is set out in the draft particulars, the court can say, okay, we'll allow you to do that subject to limitation points. But we don't have that here. We just have him saying there's nothing wrong. Unless I can assist you further, that's all I propose to say in reply.
Appreciate your submission. Thank you. Well, Mr. Rana, that's all to be said today.
That's all, Your Honor. Thank you for the time.
Yes, that's great. Yeah, okay. Usually I would deal with this in an expedited way, but unfortunately this is my last working days. But I'm going for 10 days leave, and I will start dealing with it. And so you will have my decision early September, hopefully. In this, and then yes, cost matter will be addressed accordingly. It depends on what direction I'm taking.
Yeah, noted, Your Honor.
Thank you, Judge.
Appreciate your work today. Appreciate your submission. Appreciate the preparation, and thanks for the team behind. Thank you very much all.
Thank you, Your Honor, and you have a lovely holiday. It's always tough